Back in the 1980s, the New Republic magazine ran a competition for the world's most boring headline. And there were many entries, but the one that topped the list was Worthwhile Canadian Initiative. And if the same competition were run today, I think I'd be tempted to enter the contest with, is Canadian data protection adequate? Because it's a pressing issue for some multinational businesses and a few policy wonks like me and Graham. But a question that frankly leaves the general public in Canada, the vast majority of the private sector, and indeed large sectors of our government, provincial and federal, utterly bored and utterly perplexed. It is true, as Bruno said, that the Canadian government has been providing up-to-date updates on to the EU on the and what has happened since PIPEDA, our private sector legislation, was passed back in 2000, and that's important because there has been amendments, the most significant of which impose data breach notification rules on our private sector. And I also want to say this. Privacy at the moment is a very, very, very hot topic in Canada. It's headline news at the national and provincial level, largely as a result of the Cambridge Analytica scandal and the Canadian connections there. You know, so in my other work, I've been writing about political parties and the use of data in politics and so on, which I could hopefully talk about at some point. But that has really pushed this issue to the forefront. So Canada was deemed an adequate jurisdiction, at least as far as those businesses were concerned who are subject to our federal law. And that's pretty much, you know, the 99% of the transfers. That's pretty much the issue. And also this issue does need to be addressed, as Bruno was saying, in the context of the new Canada-European Trade Agreement, CETA, which is important, even though that agreement just tends to cover manufacturing, agriculture, not so much service. So what does adequacy actually achieve for us? Well, it allows us to feel good about ourselves.
Yes, it's already a big thing.
Absolutely, if you've been following what Prime Minister Trudeau's been saying recently, in contrast to what many of us regard as the Wild West of data protection in the United States. It does relieve some businesses from the bother and expense of using model contracts abiding corporate rules. That's important. And it is true that it was a major factor, although not the only factor, in prompting Canada to pass private sector legislation back in 2000 that I was involved with. But does this process of adequacy determination do anything to actually support the fundamental privacy rights of European citizens whose data might be processed in Canada? That's my question. Has there been any case where a European citizen, through his or her DPA, has been able to assert privacy rights against a Canadian company in Canada? I do not know of one. I do not know of one. And in fact, until Max Schrems hit the scene, one would be hard-pressed to actually find any individual who has been able to assert his or her privacy rights against an organization that processes personal data on European citizens in a third country jurisdiction. Now, there may be cases that I do not know about that have not been public. So you know, we need to keep that in mind, how absolutely fundamentally difficult it is for an individual to assert rights of redress against a company that's located elsewhere. So what's all this about? In my judgment, it's about the export of an idea. And that idea is one that I fundamentally and profoundly accept and have been writing about for 20 years. I actually don't know whether Canadian data protection is adequate, let alone essentially equivalent. Analysis is going on at the moment. But to the extent that it allows me and others to argue to Canadian legislators and administrators that our standards need to be improved, it serves a fundamental purpose. And I have given testimony to our House of Commons committee over the last year, pressing them directly to improve our legislation, not in order to satisfy Bruno and his colleagues in Brussels, but in order to satisfy Canadians. That's the key point. And I think that's what Graham was saying as well.